Tell us about Annabelle. Tell me what you've observed when you've met Annabelle.
I have only seen Annabelle once, and it had nothing to do with any dog bite situation. As noted earlier in my reports, both of these incidences happened after hours.
So have you ever evaluated Annabelle's behavior?
I am not an animal behaviorist.
Have you ever evaluated her behavior?
No.
Now, you are, though, the legislative representative, right, for the Animal Control Officers Association of Massachusetts?
Correct.
So does that mean you have to know the relevant dog law as a legislative representative?
I'm not sure where you're...
Are you aware of the dangerous dog laws in Massachusetts?
Yes, I am.
How long have you been an animal control officer?
I believe since 95 or 96.
Now, you write in your report, in your June 15th report, that Ms. Mitchell's unwillingness to put up a fence is what led you to compel her to put a muzzle on her dog, correct?
No, the muzzle was going on to the dog for a temporary order. Prior to that, prior to sending out anything via mail.
So on June 15th, in your letter, the last paragraph, I've spoken with Melissa Mitchell. She's not willing to provide a fenced-in enclosure for her dog, which is why it's paramount this dog be restrained. So you didn't say, so my question here is, second question, then if she said, yes, I'll put up a fence, the way this sentence reads, then you wouldn't have ordered a muzzle, correct?
I can't answer that.
But you wrote it.
I can't answer whether I would say a muzzle or not a muzzle, Mr. Cohen.
But you wrote. Well, but you're the person who decided on your own to put a muzzle on. So what do you mean you can't say, if she had said she put up a fence, would you have muzzled the dog?
Outside of that fence? Very likely.
In the police report, you write that due to the bite history, I'll be ordering a temporary restraining order to prohibit the dog being outside unless leashed and muzzled. So is it due to the bite history or due to her not putting up a fence that you ordered it?
It was due to the bite history, and I think that bite history has been established.
And what was that bite history? Prior to this, there was one bite that you knew of, correct?
Correct. That's a history, Mr. Cohen.
Okay. Can you point to me in mass law where you have the power to order a fence?
I don't. That's why
48 hours of a bite?
There is no order for that.
Can you point me to Massachusetts law where you have the power to order a temporary restraining, what you call the temporary restraining order on the dog and her owner? Where in mass law will I find that?
You won't find that in mass law. You'll find it in our bylaw.
Okay.
Mr. Chairperson?
Go ahead, Anita.
Thank you. I just want to be sure it's really sounding like, while I want to make sure all of our questions are answered here, I would really like to make sure that we're being civil in this proceeding. And I just want to remind that Annabelle is the one that we're considering. This is feeling very uncomfortable for me. And the questioning, we should answer these questions, but I want to make sure that our motives in determining what's the best course of action for Annabelle.
Continue, Attorney Cohen.
Okay, so two of the board members have questioned my motive and one says she feels uncomfortable. Well, now you know how my client felt when the dog had to have a muzzle on for the last 30 days. So I'll move on to get something so it pertains to Annabelle. At the June 29th hearing, did you tell the board or make the board aware that you were planning to refer all of this to a behavioral consultant?
I don't believe I did at that hearing, no.
When did you decide to send it to a behavioral consultant or a behaviorist?
I would have to look back through the emails for the exact date. That could take me about 2 hours to go through all this paperwork.
But it was after the hearing?
Correct.
The June 29th hearing. Okay.
Correct.
Did anyone direct you to do that, or did you do that on your own?
I did that on my own.
Did you ever ask Ms. Mitchell to have the dog evaluated by a behaviorist?
No.
So who paid for that?
Who paid for what?
The evaluation.
Respectfully, Mr. Chair, again, while I appreciate fiscal responsibility as much as the next person, again, I'm not seeing, Mr. Chair, what who paid for the behaviorist has to do with the dangerous hiss hearing.
If we're going to do this right, there's only one way to do it right, and that's knowledge to everybody. You went behind the owner's back to get a hands-free evaluation. Why not include the owner? And so we could actually do it with somebody who would physically evaluate the dog, like be with the dog. Like, why not include her? Now, by that point, I had already put a notice of appearance, and why not say, hey, we're going to have this evaluation. We need to have it. I would agree that we have to have it. In fact, I would agree that my client should have been the one to spearhead it. But did you suggest to her, hey, have an evaluation done? There's so many local that are during COVID touching and seeing the dogs that even tell her that such a person existed. My point connecting this was, I think that in the full transparency, if we're trying to get to the right decision, there's only one way to get there. And that's to say, hey, we're going to figure this out. So we're having the dog evaluated on paper. I don't understand why that information was kept from us. That's why I was inquiring who directed it, who paid for it. In trying to figure out if Annabelle is a dangerous dog or not, did you ever call or have occasion to speak to the dog's owner about Annabelle, about her behavior?
I believe in these two instances in 2017 and 2020, yes, I did speak to her.
Did you go to the house or ever go to the site of the incident with the boy?
No, I did not. Mr. Cohen, I already stated that was after hours.
Yeah, but it hasn't been after hours since June 13th, right? I mean, there's been some time between June 13th and July 27th where you've been on hours, right? I just asked if you went to the house. I didn't ask you for the reason. Have you gone to the location where the bite happened?
No.
Okay. Are you aware that there's almost a 250-foot, although 75 feet of roaming on a tie out that my client has for her dog?
Excuse me?
Are you aware of the tie out that my client has for her dog?
Yes, she told me about it.
Do you know how big it is, how long it is?
No, I do not.
Have you suggested to her that she shorten it?
No, I did not suggest she shorten it at all.
Why not?
Why would I be suggesting she shorten a tie out? The length of the tie out really is not the issue here. It's the fact that the dog was afforded the ability to cause harm, even though it was on a tether.
You stated earlier tonight that Tim Mulligan, who is absolutely the most difficult person to ever get a hold of, how you kept up with that, it's difficult. But he had said, hey, if you need me there the next day to do a behavioral evaluation, I'll be there. And what you said tonight was you didn't think it was an appropriate reach for your department to call for that.
It is not in the purview of my department to have the dog owner's trainer to go out on my request, or as I'm guessing you are trying to state, a demand to go out there. They have a trainer that they felt confident with when I talked to Miss Mitchell. And when I talked to Tim, he did say that he was going to call the owner after we hung up the phone and discuss the situation going forward.
Prior to Annabelle putting this the muzzle restraint on her, because for whatever reason you may or may not have thought she was dangerous at the time, have you suggested that before for other dog owners, that they muzzle their dog?
I believe so. We don't do a lot of dangerous dog hearings, Mr. Cohen.
At the June 29th hearing, you acknowledge, right, that your bylaws were out of date?
I believe our town administrator stated that. I may have been in agreement with her. I cannot recite something that I don't have access to at this moment.
At the time when Mulligan wasn't getting back to you, the trainer, but you stated this is the missing piece of the puzzle. What does Mulligan have to say? Did you ever reach out to my client and say, hey, you got to get this trainer to call me? or write a report? Did you try to put pressure on her to put pressure on him so you would finally get an answer?
It would have happened if I did not hear back from her after that Zoom meeting. If I hadn't have heard back from him and made contact after that Zoom meeting.
So you'd said at the June 29th hearing, if the trainer gives me a set plan, it would change my recommendation for a hearing. And I know you didn't call for this hearing. The complainant did. Is anything that Mulligan shared with you? So at the time then, if you didn't want to have a dangerous dog hearing, then that would lead me to believe that you didn't think the dog was dangerous. It didn't need to be labeled dangerous, because you said if the trainer gives me a set plan, it wouldn't change my recommendation for a hearing.
Now we'll take a closing remark from the dog owner. Go right ahead, Ms. Mitchell.
Mr. Chair, she's deferring that option to me.
Go right ahead, Mr. Cohen.
Thank you. The catalyst for this was the grandmother's error. And again, the statute that we're operating under, it compels the hearing authority to look at whether you can find it or not, but to look at the dog's behavior in that, under that circumstance. It's certainly important that we protect the public from dangerous dogs, really from any dog. But it's also important that we protect the public's right to due process in a fair hearing. I'm not saying this hearing wasn't fair, just the due process of being able to put on an accurate defense. Mass General Law doesn't consider the Dunbar scale, and nowhere in it does it. What it does consider is that, as you know the definition, no dog should be deemed dangerous if the dog was reacting to another animal or to a person, and the dog's reaction was not grossly disproportionate to any of the following circumstances. This is 157 little a, number 1. It's from the dog's perspective. The dog was protecting or defending itself, its offspring, another domestic animal, or a person from attack or assault. Here, we have some evidence that this dog was certainly in protective mode. It was protecting the son that lives at the dog's house. We don't have anybody who has been able to either determine the dog's state of mind at the time, but Mass General Law requires you to, as the hearing authority. And then under that section, instead of number 1, number 3, it also says that the person attacked or threatened by the dog was engaged in teasing, tormenting, battering, assaulting, injuring, or otherwise provoking the dog. Now, this boy was not doing anything affirmatively or physically to provoke the dog. I think we've established that, the injured boy. But who I'm just choosing not to name out of respect. But from the dog's perspective, the dog's let out there and she sees her housemate, and then she sees this other boy with a mask and a hat. I've heard testimony that is what was on. I haven't, so I accept that. Doesn't mean you have to. And in this dog's mind, we now, knowing those circumstances and that this hasn't happened before, first dog on human on her very property. And we're not insinuating that the boy was trespassing or anything like that. We're not going there, but we're saying you've got to look at the law in relation to all the facts, not just what the behavioral expert assumes went down there based solely on the scope of the bite. The law doesn't say to go based off the scope of the bite. It says, was the dog protecting or defending itself, its offspring, another domestic animal, or a person from attack or assault? In this dog's mind, there was an attack pending and this was an assault based on what the dog sees when it comes out of the house. And plus it was on its very property. How else can you say, if this dog did it at the dog park, that's a different story. This dog did it on its own property. And that's why, even though nobody can give a definitive answer of what was going on in the dog's head, you can look at the circumstances here and know that the dog was in protective mode. Also, in terms of the scope of the reaction of the dog, to the Bichkowskis, and to us, it's a bad bite. But in the scheme of bites, dogs that are dangerous and have that intent to kill or maim or destroy, they don't bite like this. And what I'm hearing, what I haven't heard, is that we haven't really been able to identify whether the dog's response to seeing the boy there was proportionate or not. I'll argue it was. Their expert will argue it wasn't. But I think that in order to really understand this, in not being made aware previously that this was on the table, we should suspend the hearing, not take any more public testimony, but we should allow Annabelle to be evaluated by a behaviorist on our end. And the great thing about the animal behaviorist world, as Ms. Boland can say, is it's not like the personal injury world where you hire an opinion, you pay for an opinion. These people, there's not a lot of them, and they have their reputations are so important. You cannot buy an opinion. And I'm willing to stand by if we can gather whatever records you want, if you want to show the scope of the injuries even more, and have another behaviorist, not a consultant, not a trainer, but a behaviorist. I think it's only fair that we get to have that dog evaluated by one of our behaviorists. In light of the fact that a lot of the information presented today was not available to the behaviorists previously, I would have, and if you're going to evaluate the dog, in my world, in the world of law and dogs, okay, not behaviors, but law and dogs, you've got to evaluate the dog. There's a series of tests. You've got to put these other triggers near the dog, because we've only heard of one trigger, wheels. No one else has mentioned any other triggers. We don't know. We got to find out, is a person on the property who has a mask and a hat on, is that scary enough for the dog to react the way it did? And we keep saying, the boy was authorized to be there, he was invited there, but Annabelle doesn't know that. And the statute requires that you have to look at the circumstances of the dog's behavior, not just the bite. Any dog can bite, and anyone can say a dog bites like that is dangerous. The real test is can you look at the facts, and can you match it up with the governing law? Because 14157 here is what controls. And I'll remind the board, your bylaws do not control here. And for anybody who said we're looking to litigate, I don't sue towns. You have discretionary right. There's no litigation here. We just want to make sure the right decision is reached. So I contend that you don't have enough information, and I don't have enough information, honestly, to know if you're getting to the right answer the right way or not. And I think that there should be one more piece in a short period, although it's hard to find behaviorists who can do it on a short period, but we have to find somebody. Until then, whatever's in place, although we disagree with the legality of it, would remain in place. And get Annabelle evaluated one more time with everybody knowing about it, and with everybody being able to submit as much paperwork as they want. It would have been helpful to know that this evaluation was taking place. As I said, I had already noticed my appearance, because there were certain things that I would have wanted to submit. And that's what I'm asking the board to do in lieu of finding the dog not dangerous under the statute. Thank you for the time.